Well, good evening, everybody, and welcome back to AJ 101 Criminal Law Online. And this will be your Chapter 3 lecture. And Chapter 3 is going to cover the elements of crime and corpus delicti. And what's kind of cool about this chapter is simply the word corpus delicti, because we have a lot of different kind of thoughts on what that really means. And we're going to discuss that on what corpus delicti means and how it kind of came to be. So corpus delicti means the total body of the crime. It includes the act or omission and the existence of a criminal agency. And criminal agency is basically the person that commits it. Okay. Or the group that commits it. It has to do with the rules of evidence which govern proof of the commission of crimes, particularly as concern the act, the element thereof, and the commission of the act by that human agency. So the corpus delicti, or substance of the crime, is applicable to any crime and relates particularly to the act, element of criminality, that being that a certain prohibited act has been committed or result accomplished, and that it was committed or accomplished by a criminal human agency. And I know that's a lot of, again, legalese, but here it's kind of broken down a little bit easier for everybody to understand. So corpus delicti, known as the total body of the crime, and there are key ingredients, okay, that we kind of covered in the little summary that I just gave. So the key ingredients are act or omission to act and the existence of criminal agency. The corpus delicti deals with the rules of evidence which govern the commission of crimes, proof of act and criminal agency, as opposed to harm caused by an act of loss, damage, or injury by accident or misfortune. So, a lot of people think, and we'll talk more about this in subsequent chapters, that, they view the corpus delicti as like the body, like the actual dead body, but that's really not what it is. So it is that whole total body of the crime. And later on we'll talk about, proof of corpus delicti. The prosecution must establish that corpus delicti of a crime, and failure to do so could really prohibit, if you will, further prosecution. So again, we'll talk a little bit more about that later, but because the corpus is simply proof of injury, harm, or loss caused by criminal agency, the term corpus delicti is not synonymous with elements of the crime that we're going to kind of cover in a minute. So, for example, the corpus delicti of all homicides is the same: death by criminal agency. Okay, if that makes any sense, and it should. But the elements of first-degree murder, second-degree murder, voluntary manslaughter, and involuntary manslaughter, they're all different. So hopefully that kind of sheds a little light on what that means. So we kind of touched on the crime elements a second ago, so let's go ahead and go there. Crime elements come from the codes. Okay, those codes that you will see basically listed in, like, the California Penal Code. And these are essential elements required for prosecution purposes. And the example could be like Penal Code, okay, 459, burglary. So as a practical matter, the Penal Code definition of a crime clearly states those essential elements necessary to the commission of that particular crime. The elements of a crime can be determined from carefully reading the statute. So this example we're going to talk about now, burglary, references made to, number one, anyone who enters. Okay, number two, a certain kind of structure. Number three, with the intent to commit grand or petty theft. Or number four, any felony therein. In this case, the certain essential elements to the commission of this crime are reflected by analysis of the code section, which would be one who enters a certain type of structure with intent to commit grand or petty theft or any felony therein. So the elements of these specific crimes, we'll explain a little bit more about these later on, but that's a really good example of the elements of that type of crime. So in addition to the statutory elements, some crimes also contain judicially implied elements. Okay, and these extra elements will not be found in the statute, but only in case law and in published jury instructions known as the CalCrim for California criminal. For example, the statutory definition of robbery contains only 4 elements. So the first would be taking of property possessed by another. The second would be from the person or presence of the victim. The third would be against the victim's will. And the fourth would be by means of force or fear. And we'll talk more about that later on. CalCrim 1600, though, so that California criminal information I was talking about a little bit ago, adds an additional element that must be proven to establish robbery. That is, the perpetrator or the suspect, if you will, and you'll hear perpetrator kind of throughout the textbook, but that's kind of the suspect or the one committing the crime, must have intended to permanently deprive the owner of possession or withhold possession for so long as a time as to diminish the value to the owner, etc. And there's a case that goes with it, kind of People versus Avery. But that's an example of a judicially applied element. So it's found in the case law and in jury instructions. And the example again was the robbery part that we kind of talked about. So proof of corpus delicti. I kind of got ahead of myself in the first slide. So we touched on it a little bit already. The prosecution has to establish the corpus delicti of a crime. Failure to do so may bar further prosecution. The amount of proof needed not to go beyond prima facie, which means on face value proof. You may have sufficient evidence of the corpus even though you're lacking proof of all elements of the crime. And finally, the corpus delicti and the elements of the crime are not the same thing, and we kind of went over that a little bit as well. So hopefully you have a pretty decent idea on kind of where we're going as it relates to corpus delicti. So a little bit more as we kind of get through this part. The corpus of a crime may be proven solely by circumstantial evidence. So when you're talking about this corpus or corpus delicti, you don't need every single piece of evidence there. It can be proven solely by circumstantial evidence. However, and there's always kind of a however sometimes, the identity of the perpetrator or suspect cannot prove the corpus. Motive is not part of proving the corpus. The law does not permit establishing the corpus delicti of a crime based solely on the confession or admission of the accused. Now, of course, you may certainly use the person's statement of admission or confession to investigate further. Okay, but what you need to know is that the corpus of a crime may be proven solely by circumstantial evidence, but there are some exceptions that we kind of just went over. So hopefully that kind of clears up some of those things as well. Now, circumstantial evidence, I just kind of want to make sure that we understand what that is, and I think we kind of went through that. The identity of the perpetrator, the identity of the suspect of a criminal offense is not a necessary and essential part of that corpus delicti, nor is such necessary to establishing proof of the corpus delicti. Thus, in order to prove the corpus delicti of burglary, it is necessary to prove that an entry of a structure was made and that it was done with specific intent of committing a theft or felony. However, it is not necessary that the identity or the name of the person who entered be known to the police. So hopefully that kind of, gives you another example, if you will, on the proof of this thing they call corpus delicti. And I would really suggest that you kind of read your terms again, the handout that I gave you to really understand some of the definitions. So let's kind of move into the criminal act. Okay, so Penal Code 20 states that in order to constitute a crime, there must be a unity of act and intent, or criminal negligence. The joint operation of an act and general criminal intent is essential to constitute any type of crime. And the name for this is called concurrence. This is also known as joint operation and intent, which I just kind of went over. An act is defined as an effect produced through conscious exertion of will. So an act is simply defined as an effect produced through the conscious exertion of will. The act varies with each crime, of course, and for that reason, it is a bit difficult to define. In some cases, it may be a physical or muscular movement, while in others, it may be an omission or a failure to act. Now, the act may involve passive participation in crime or activity outside of the state, which results in a crime within the state. It could be a series of acts, proximate results, or just the mere doing of something. An example would be the result of some human agency. So, for example, here in a homicide case, the act is the killing of a human being. In larceny, it is the taking and carrying away of personal property of another. In arson, it is the burning of real or personal property. In rape, it is the having of forced sexual intercourse. In each of these cases, the act is muscular or physical in character. However, it need not always be, as in the case of omission, okay, failing to act, or to act passively participating in a crime. So let me give you a little bit more of an understanding on what omission is so you can kind of wrap your head around it. So omission to act means basically a mere omission to act may be sufficient to complete a crime. Such omissions are generally characteristics of those crimes which involve the failure to perform a duty imposed by law. In many such crimes, there is a lack of physical movement on the part of the perpetrator or the suspect. Examples are failure to provide a minor child with necessities, Penal Code 270, causing a child to suffer, Penal Code 273A, or contributing to the delinquency of a minor by omitting the performance of a legally imposed duty. So here you're failing to act, okay, but that still constitutes, the criminal kind of undertone that we're talking about. Under certain circumstances, a factual situation may be sufficient to give rise to a legal duty to act for the benefit of another. So an example here would be one who undertakes to render aid to another may not be legally bound to do so, but having commenced such an undertaking, he cannot later abandon such purpose if the person is being aided will suffer further harm as a result of the partial performance. Ordinarily, however, the criminal law will recognize a negative act or a omission to act only if the one who has failed to take affirmative action was under a legal duty, okay, to do what was not done. So that's a little bit more information as it relates to omission to act, so you kind of understand it. So here we'll kind of look at it again, just a little bit more focused, if you will, so you can get a good handle on it. So the criminal act continued. the omission to act, failure to perform a duty imposed by law. Example they have here: failure to pay taxes, child endangerment. Passive participation, we talked about that. Criminal liability may result from passively participating in a crime. Example, providing drug paraphernalia to a user. Acts of possession, you may be convicted of a crime simply by possessing an illegal item. These offenses generally require knowledge as a state of mind, but also just this act of possession. Keep that in mind, that you can be convicted of a crime simply by possessing an illegal item, provided, of course, that you do know that it was, illegal to possess in the first place. So, multiple offenses punishment. Punishment for two offenses arising from the same act is prohibited by the Constitution of the United States and again by the California Constitution. So here, whenever an act or omission could be punished under more than one statute, it is to be punished under the provision imposing the greatest punishment, but may not be punished more than once, Penal Code 654. So that gives you kind of a reference point to where you can find a little bit more information about this thing called dual convictions, or multiple punishments, if you will. So while Penal Code 654 prohibits multiple punishments for a single act or omission which may violate more than one statute, it was modified in a case titled In Re Hayes. And in this Hayes case, the defendant was convicted of 1, driving with a suspended license, and 2, driving while intoxicated based on the operation of an automobile on one occasion. Now, the Supreme Court ruled that Penal Code 654 prohibits multiple punishment for a single act or omission which is made punishable by different statutes, that is, a single criminal act or omission. The court said that since the mere act of driving is not made punishable by any statute, it is not the type of act or omission referred to in Section 654. The acts made punishable were 1, driving while intoxicated, and 2, driving with a suspended license. 2 separate and distinct criminal acts. So both criminal acts were committed simultaneously and share in common the neutral non-criminal act of driving. So this does not render the petitioner's punishment for both crimes in conflict with Penal Code 654. So that's the long way of saying that, hey, he could be charged for both of those items. So now we're going to look at something that's kind of falls under the term causation. And the term that we're going to be discussing here for a minute is called proximate cause. Now, so what is it? Okay, now Cochran's Law Dictionary, the Police Edition, defines proximate cause as that which produces an event and without which the event could not have occurred. So that word causation kind of comes into play here. So what is causation? Is the causal relationship between conduct and the result. And this in itself can lead to criminal liability. So this relationship exists when a defendant's act is the proximate cause of an injury. And a defendant is liable for direct or proximate causes. A defendant is not liable for indirect or remote consequences. So kind of moving on here, there is some causal relationship or proximate cause that must exist between the defendant's act or the act of another in his behalf and the prohibited result, which constitutes the crime. This causal relationship is said to exist when the defendant's act was the proximate cause of the injury inflicted, which we kind of talked about. So to be proximate, the defendant's act need only be a contributing cause, as in the case of concurrent acts of two persons acting with common design. So and I understand that some of this kind of seems a little bit difficult to understand. But again, this is where when you're in your textbook, you can start to look up kind of some of these things and get a little bit more kind of honed in on exactly what these definitions actually mean. So staying with proximate cause for a minute, so stay with me here. We're going to get this thing called attributed liability in homicide, and California courts recognize three theories of what they call attributing liability in a homicide case that results from the commission of other crimes. And these theories are the felony murder rule, the vicarious liability doctrine, and the provocative act liability. So as we kind of look at these, I'll give you a little bit of a kind of blurb on each one of these. So again, California courts recognize three different theories for attributing liability for a homicide that incidentally results during the commission of other criminal activities, such as robbery, burglary, and kidnapping, for example. So, number one, again, the felony murder rule; two, vicarious liability doctrine; three, proximate cause, or the provocative act liability. So the felony murder rule. Under the felony murder rule, all persons aiding and abetting the commission of any felony listed in Penal Code 189, talking about first-degree murder, are guilty of first-degree murder when any one of them kills in furtherance of the common design. The felony murder rule does not apply to situations in which the intended felony victim kills a suspect in self-defense, or where a suspect is killed by responding police. It applies only if one of the suspects kill in furtherance of criminal conspiracy. The vicarious liability doctrine holds that where two or more suspects have agreed to kill as part of their plan to carry out their crimes, each of the suspects is guilty of murder when any one of them kills. So, for example, a carload of gang members agree to do a drive-by shooting to kill a rival gang member. All of the suspects will be liable for the resulting murder, even though only one of them actually did the killing. And then the last one, the provocative act theory. Under the proximate cause provocative act theory, surviving accomplices can be convicted of murder where the intended victim or police kill one of the accomplices in response to a provocative act committed by one of the surviving accomplices. People versus Gilbert is the case that kind of goes with it. However, if the suspect who committed the provocative act, such as starting a gunfight, is killed by the third party and none of the other suspects committing any such provocative acts themselves, they cannot be convicted of murder for their co-conspirators' death. So again, a little bit confusing, but kind of read into those things, and I put some slides up here for you to kind of look at to help you understand it, because it kind of focuses it down and takes some of the legal ease out of it. So just kind of in review here, felony murder rule. Under this rule, if a homicide occurs during the commission or attempt to commit certain serious felonies, we can use rape, robbery, etc. It is first-degree murder regardless of whether the killing was intentional or unintentional. This legal doctrine derived from common law is now found in Penal Code 189. The killing must be in furtherance of the common design or for the particular group, if you will. Vicarious liability applies to hold one person liable for the actions of another when engaged in some form of joint or collective activity. In California, where two or more people agree to kill as part of their plan to carry out the crimes and one of them does, all are guilty of murder, and the example here was the same as I used earlier, which was the basically drive-by shooting, where all would be subject to prosecution for that. And then we have the provocative act doctrine applies when someone commits an act that provokes someone into killing someone else. Now, the classic example here is an attempted murder in which the victim is provoked into firing a gun in self-defense, killing a bystander or an accomplice in the attempted murder. The California Supreme Court kind of narrowed this doctrine down by making it very clear that to be guilty of first-degree murder, all participants must act willfully, deliberately, and with premeditation. And I'll let you look up the word premeditation, or if you took your terminology quiz, the one that wasn't graded, but you still get to take it, you'll know what premeditation means. So I'll kind of leave it at that for you. So the scope of criminal liability. So kind of, how does that all work, and what is the scope? Well, except in strict liability cases, all crimes require certain things. So there has to be some things there. Well, again, except in strict liability cases, all crimes require an act or omission to act, which would be the failure to act, intent or criminal negligence, concurrence, meaning unity of act and intent, and causation, conduct that leads to an end result. So all of these, okay, all crimes require these specific items there. So a little bit kind of continuing here in common law, our understanding of criminal liability derived from Latin terms, and you'll see these again, so these are good and they'll be in your terminology quiz. The term actus reus means the act. The act can consist of commission, omission, or possession. Okay, the term mens rea means guilty mind, usually referred to as intent. And modern penal codes have created levels of mens rea basically called modes of culpability. And we're going to talk a little bit more about intent in a few minutes as we kind of move into that area. So intent anyway, just to kind of, I guess, get there, may be generally defined as a design or resolve or determination of the mind. It's also defined as the act or fact of intending or purposing. Intent, purpose for which is formed in the mind, and similarly design, resolve, determination of the mind. So these are all from Boivier's Law Dictionary or Cochrane's Law Dictionary that talk about intent, and I think we're going to talk about evidence of intent in a few minutes anyway, so we'll kind of get into that. So intent, the types of intent, and we'll look at general intent, we'll look at specific intent and the differences between the two. So kind of backing up the bus for a minute, criminal intent defined as a design, resolve, or determination of the mind. Penal Code 21 subsection A states that intent is manifested by these circumstances connected with the offense. Law states that all persons are capable of committing crimes except those listed in Penal Code 26, which again is why the internet's going to help you out here, where you can actually kind of look up some of these sections and you'll know the exception to the rule here. So if the law says that, hey, all persons are capable of committing crimes except those in Penal Code 26, if you look in Penal Code 26, it's going to tell you the exceptions to those. Okay? An unlawful act is presumed to have been done with intent to violate the law. So that's kind of the norm unless it can be proven differently later on. So what are the types of intent? Because we kind of talked about intent for a minute here. The evidence or what have you. So there are three main types of intent. There's general intent, specific intent, and then what they call transferred intent, also known as constructive intent. But you'll usually hear more on the the term transferred intent is kind of what you typically hear. So what is general intent? Let's kind of start with that one. So most crimes are general intent crimes. The elements are the mere doing of an act in violation of the law without legal justification or excuse. General intent may exist even when one thinks their acts are right or lawful. The law presumes that persons intend the consequences of their acts. So the law basically says that, people know the outcome of whatever it is that they're doing. So you kind of put those two things together again. So the law presumes that persons intend the consequences of their acts. So some crimes, by their very nature, are perpetrated by the intentional doing of an act. In these cases, there is no necessity of proving the actual intent to commit the crime. General intent statutes enacted under the police power of the state are good examples of this rule. So there's a couple of exceptions that kind of fall in here, but for the most part, this is kind of a good outline of general intent and gives you a pretty good idea of what I'm talking about. So specific intent. So we talked about general. Specific intent, when a crime consists not merely in doing the act, but doing the act with a specific intent. That intent is an essential element of that crime. The statute may require a designated state of mind necessary to commit the crime. You will generally find this intent in the statute or code language. An example would be every person with the intent to or for the purpose of. So a pretty good example of specific intent could be found under, let's just say, burglary. So we looked at the elements of burglary earlier on, didn't we? And I'm going to kind of ask you, just to kind of think back, do you recall what the elements of burglary are? And if you do, well, think about it. So we have, one who enters, okay, a certain kind of structure with the intent to commit what? Grand or petty theft or any felony therein. So that is a specific intent crime. Okay, does that make sense? And hopefully that it does. So specific intent, it'll be listed in the code as, like in burglary, as specific intent. So hopefully that example is kind of good enough for you. Additionally, most crimes, with the exception of the theft statute, will include the phrase I could put here, with intent, to signify the necessity of proving specific intent as an independent factor. So there you go, the example I gave. Thus, in the crime of burglary, entering a structure with specific intent to commit a theft or felony is a necessary element of that crime. Certain penal statutes also provide for the assault with intent to commit crime. So like sodomy, rape, robbery, mayhem, or the attempt to commit a crime. In both cases, proving specific intent would be necessary in an assault to commit type crime or in an attempt to commit a crime. So thus, in the crime of assault with intent to commit rape, evidence must show that the assault was committed with intent, specifically to rape the victim, if that makes sense. And I think that kind of makes it pretty clear. And we're not going to spend too much more time on that. And then the last one of the three that we were kind of exposed to here is called transferred intent, also known as constructive intent, defined as crediting liability to the perpetrator or the suspect for the unintended consequences of their acts. The intent is transferred from the party who was the intended victim to the unintended party that is the subject to the loss or injury. So an example here, which is pretty basic, but it's a good one. John intending to shoot Steve misses and instead shoots a bystander named Cindy. The law transfers John's intent towards Steve to the injury received by Cindy in this case. And I'm not going to muddy the waters too much more on that because that is actually a pretty decent example on that. So we've got some three kinds of intent here, and now how do we prove it? How is intent proved? Well, criminal intent, general, specific, and transferred, like the ones we've been talking about, may be proven by circumstantial evidence and may be inferred from the manner in which the unlawful act was committed. A little more you can find in People versus Hunt. Intent, all three types, may also be proved by or proven by direct evidence, such as words spoken by the defendant or by the circumstances surrounding the crime. The accused may have told someone of his or her intentions before committing the crime. Also, the suspect may have made a statement such as, this is a robbery. During the commission of the crime, those words spoken by the accused during an assault may very well reveal his intent to rape, commit mayhem, or some other crime. So for the purpose of proving intent, the conduct of the defendant before, during, and after the offense is admissible to prove that intent. So a couple other things here. Criminal intent may be proven by direct evidence like we talked about, which could be an eyewitness. Criminal intent may also be proven by circumstantial or indirect evidence, may be inferred by the unlawful act committed. And finally, as we just got done talking about, the conduct of the defendant before, during, and after is certainly admissible in a case to prove intent. So moving on a little bit, and we got to kind of pick up the pace a little bit. We'll talk a little bit about intent in negligence cases. Criminal negligence consists in reckless or indifferent omission to do what a reasonable and prudent person would do or not do under the same set of circumstances. So to be guilty of a crime, a person must act with what they call mens rea. We talked about that a minute ago, or criminal intent, the mind, right? Normally, this means intentionally or deliberately pursuing a criminal result, but criminal negligence may substitute for criminal intent under certain circumstances. Now, this negligence is usually stated as a wanton or conscious disregard for the safety of others, or what they call willful indifference. Okay, so criminal negligence is something beyond ordinary negligence. It amounts to kind of gross or a culpable wrongdoing, departure from the required standard of care almost. Criminal negligence is conduct so aggravated or reckless that it shows indifference to the consequences and a disregard for human life. And you can find more in People versus Peabody. And there are generally factors, okay, 5 of them actually, that need to be considered in order to find intent from criminal negligence. And the defendant here must, 1, have a legal duty toward the person, 2, know the legal duty and the danger, 3, be able to perform the legal duty, 4, fail to perform the duty, or 5, appear that the negligent act caused the injury. So all of these are those 5 factors to consider in order to find intent from criminal negligence. So an example could be an operator of a motor vehicle who drove in excess of 50 miles per hour in a residential area and killed a pedestrian whom he did not see was guilty of gross negligence and of manslaughter. That case is People versus Flores. In this case, Flores had a legal duty to drive within the speed limit. A lack of what they call due caution and circumspection referred to in Penal Code 192 manslaughter places a criminal responsibility on a defendant who acts without due caution and circumspection and is equivalent to criminal negligence. People versus Hurley. You can find that on page 45 in your book. So hopefully that gives you kind of a little idea of negligence. Okay, moving on. So we'll talk a little bit about malice and what that means. And you've probably heard the word before, especially because I know you did your terminology quiz. So what does malice really mean? The term malice has been used synonymously with general intent and is usually regarded as indicating a mental condition more intent on harm or injury than is involved in general intent to commit a crime. Malice means basically a wrongful act done intentionally without justification or excuse. Found in Penal Code 7, Penal Code 188, Penal Code 450 to define different types of crimes. Express malice found in Penal Code 188 is the deliberate intention to kill another person, and implied malice in that same Penal Code 188, killing shows a basically abandoned and what they call a malignant heart or cold-hearted disregard for somebody else's safety. So again, to kind of summarize those express and implied, malice is express when there is manifested a deliberate intention to unlawfully take away the life of a fellow creature, if you will, and malice is implied when no considerable provocation appears or when the circumstances attending the killing show on abandoned and malignant heart. When it is shown that the killing resulted from the intentional doing of an act with express or implied malice as defined above, no other mental state need be shown to establish the mental state of what they call malice aforethought. And we'll kind of get into a few of these other terms as we move on. So motive and intent, and these are things that you've heard. I'm sure you've heard the term motive before. So motive and intent kind of distinguish between the two. Motive is the desire or the inducement which incites or stimulates a person to do an act, as contrasted with intent, which is the purpose or resolve to do an act. So while motive is not a necessary element of a crime, it may help prove the intent necessary to the consummation of a crime. So let me try to think of an example for motive that's actually kind of interesting. So motive. So when I was the chief in Rialto, there was a series of burglaries, nighttime burglaries, and this particular person would basically burglarize the homes of single women. And part of what he did is he would watch them for a while, and he would kind of get their routine down. He would wait until they are at home alone. And typically they would live alone. He would break into their home through an unlocked window, unlocked door, or what have you. Rarely ever forcing entry, typically again a sliding glass door or something like that. And while the female was asleep, he would take a few trophies, which would be like women's underwear and things like that. And before he would leave the premise, he would basically tickle their feet. I know it's kind of disgusting and weird. Now you're going to freak out and you won't be able to sleep. He would tickle their feet up to the point of when they would just kind of come out of their sleep and they would be able to see the suspect just kind of in the shadows, and then the suspect would disappear. So think of that. So that's the motive, the desire. What was that guy's desire or inducement which stimulated the person to do an act? Was it the fact she was home alone, or it was just a female, or he would wake them up so they could sort of see them, as opposed to the intent or the purpose to do the act? So you can, hopefully that's kind of an okay example when it comes to describing motive. And they ended up catching this guy, just so you know, so he's not going to be out there tickling any more feet. But he did break into probably 15 or 20 homes, and they had a big task force, and he got arrested, and everything was cool. But just, again, kind of a weird thing. Okay, so we're getting close to the end here. We'll kind of finish up with intoxication as affecting intent, meaning impacting. So the evidence of voluntary intoxication shall not be admitted to negate the capacity to form any mental state for the crimes charged with which the accused committed the act, including but not limited to purpose, intent, knowledge, premeditation, deliberation, or malice aforethought. So in California, okay, drunkenness, whether voluntary or involuntary, is never an excuse for the commission of a crime. However, in considering the effect upon the guilt of the defendant, the law makes a distinction between intoxication, which is voluntary, and that which is involuntary. Now, both voluntary and involuntary intoxication are explained in your textbook a little bit more as we kind of go through here. And I'll give you, before we hit diminished capacity here, I'll kind of talk about it for just a second. So voluntary intoxication includes the voluntary ingestion, injection, or taking by means of any other means, any intoxicating liquor, drug, or other substance. Intoxication of a person is voluntary if it results from his willing use of any intoxicating liquor, drug, or other substance, knowing that it is capable of an intoxicating type effect when he or she willingly assumes that risk, etc. So evidence from voluntary intoxication shall not be admitted to negate the capacity to form any mental state, if you will, for the crimes charged, including but not limited to purpose, intent, knowledge, premeditation, deliberation, malice aforethought, which we kind of already talked about. Evidence of voluntary intoxication is admissible solely on the issue of whether or not the defendant actually formed a required specific intent, or when charged with murder, whether the defendant premeditated, deliberately deliberated, or harbored express malice aforethought. So there's the voluntary. Now, the involuntary intoxication is said to be involuntary when a person does not willingly and knowingly consume intoxicants, but is either fraudulently induced to partake in intoxicants or does so in such a manner that he is not aware of such a fact, where a person becomes involuntarily intoxicated. The law recognizes the fact that a person cannot be held criminally responsible for that particular act. However, depending upon the extent or degree of intoxication, a person who is involuntarily intoxicated may or may not have the ability to realize what he is doing. So in such cases, the degree of intoxication is a question of fact for the judge or the jury to decide. Diminished capacity. The defense of diminished capacity we talked about in a previous chapter was abolished by the passage of Proposition 8, so really don't have to worry about that. Evidence of diminished capacity or proof of mental disorder may still be considered by the court, but only at the time of sentencing or other disposition or commitment after the issue of guilt or innocence has already been determined, Penal Code 25, subsection C. So that's going to wrap up Chapter 3. Again, make sure you go through your terminology quiz and get a good understanding of those terms, okay? So until we talk again, that's the end of Chapter 3, not free, but well, it is free, I guess. And if you have any questions, please post them on the discussion board, and I'd be happy to answer any of your questions. So until we talk again.